Hey, it's Bernard Nomberg with the Nomberg Law Firm in Birmingham, and wanted to talk for a minute or two about what are some of the defenses that are commonly used against an injured worker in a workers' compensation matter. And there really are too many to list them all here, but some of the more common ones that we have seen and dealt with would be the following, in no particular order. One, the employer is not subject to the Alabama Workers' Compensation Act, meaning they didn't meet the requirements for employers. Now, there may be other types of claims that can be pursued, but this is not under the Work Comp Act. Willful conduct on behalf of the injured worker. If the injured worker was not in the line and scope or course of his business, when he got hurt, but he was doing something intentionally and that ended up harming him. A case in point would be maybe picking a fight with a co-employee where he instigated it. Intoxication certainly could be a defense. That really needs no further discussion there. Misrepresentation about the type of injuries, how the person got hurt, pre-existing conditions, just any type of misrepresentation. The statute of limitations. There's a limited period of time in which a claim can be brought, and so the statute of limitations can be used. Pre-existing injuries, again, if an injured worker has pre-existing condition or injuries that actually limited their ability to work and then they got hurt and then claim they had a new injury when in fact they were under doctor's care, and it's more complicated than that, but that can be used. There can be a set-off of benefits. When you have the interaction of work comp benefits, long-term or short-term benefits, and Social Security disability, that can be not a bar, but maybe a defense or a mitigation of certain damages. There's so many others. Those are probably the main few. Contributory negligence, by the way, cannot be used against an injured worker in most instances. Because we're in the Alabama Workers' Compensation Act is a no-fault statute. Typically, the employee's own negligence that may have caused or contributed to the accident and injuries typically can't be used as a defense. But I will caution you this, that every single situation is fact-specific. Every single situation has to be reviewed thoroughly for all defenses, all types of matter under the Work Comp Act. If you've been hurt on the job and think you may have a claim, please give us a call. We deal with that every day. We may be reached at 205-930-6900 or nomberglaw.com on the internet. We can also be found on YouTube, Facebook, and Twitter.